Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Michegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. I wasn't ready. I wasn't quite ready because I'm always rushing. Hi, everyone. Hello. Good afternoon. To those of you who are coming over from Sarah Boone's stream from this morning, welcome back. We're here. We're here for it. There's going to be a hearing at 1:30 on Ashley Benefield on the juror issue. And so I have the state's responsive papers for you that we're going to take a look at. First, their opposition that they just filed on the 14th of October, which I believe was after the hearing that they did that was not televised for the jurors. So this judge in Florida, in Manatee County, called the jurors back in after the verdict. Remember, Ashley Benefield has been convicted in the murder of Doug Benefield, or the manslaughter of Doug Benefield. And subsequent to the jury having reached the verdict, the defense came up with some information that perhaps one of the jurors had lied on the jury questionnaire. And she was found guilty of manslaughter. Her sentencing is supposed to be tomorrow morning, but depending on what happens with this motion, it may be moot. So let's take a look at these opposition papers. Yeah, I did it. I swiped myself out. Sorry. You guys have been here for it. Not the first time. Not the first time that's going to happen. Not the last time that's going to happen. Let's get back to the motion papers. Because these papers are going to tell us a little bit about what happened during the juror interviews. This is Judge Dewey. Is this? No, who's this judge again? Why is his name escaping me right now? I'm thinking of Dewey K. Arthur, but that was in the Carly Gregg trial. So, I'm conflating all of my trials now. Okay, here is, this was filed on the 14th of October. This is in Manatee County. We are currently in Orange County for Sarah Boone. So we're just moving to a different part of Florida right now. This is the state's response to the defense motion for a new trial based on juror misconduct, post-juror interviews, and memorandum. Remember, these two prosecutors are sort of like the evil stepsisters of the true crime defense attorney world. If you know, you know. State's response to defense motion for new trial, blah, blah, blah. Comes now, Assistant State Attorney for the 12th Judicial District. And here's what we want. Here's our response to this motion regarding juror non-disclosure. The defense alleges that juror 15 was untruthful on the juror questionnaire and failed to disclose her involvement in child custody / domestic violence / abuse matters. In determining whether a juror's non-disclosure of information during voir dire warrants a new trial, courts have generally utilized the three-part test. First, the complaining party must establish that the information is relevant and material to the jury service in the case. I say yes. I say they've met that prong. Second, the juror concealed the information during questioning. We'll see if they met that prong. And lastly, that the failure to disclose the information was not attributable to the complaining party's lack of diligence, meaning that the Neil Taylor failed to question them. That's gonna be the crux of their arguments here. The defense alleges three areas that juror 15 was untruthful. The allegations are that she did not disclose, number one, that she had been a victim of domestic battery in the past. Number two, that her son had previously been charged with a felony domestic battery. And three, that she had involvement in child custody / domestic abuse / abuse matters. I'm sorry, child custody / domestic violence / abuse matters. As to number one, juror 15 testified at the hearing to interview jurors that she answered no on the questionnaire to the question, quote, have you or your family member been the victim of a crime? Because she did not associate the vague question about being a victim, end quote, with the crime of domestic violence. Let me know what you think about that. Assuming because of her misunderstanding that she answered the question incorrectly, the defense has failed to establish that juror 15, being the victim of domestic violence, was relevant and material to her jury service. The Ashley Benefield case centered around domestic violence. It was absolutely 100% relevant and material, in my opinion. Based on the defense theory of self-defense because of prior domestic violence, it is reasonable to assume that a juror who was previously a victim of domestic violence would have been sympathetic to the defendant's theory of the case and potentially biased against the state. Wrong. I will tell you from people in my own chat, from comments I have looked at in other chats regarding Ashley Benefield, from comments on other videos and my own videos, many people feel I was a victim of domestic violence and therefore I know she's lying. Or I was a victim of domestic violence and I had it so much worse than Ashley Benefield ever did. And I never killed him or her, because men are victims too. So, no, I disagree. Courts have determined that depending on the specific facts of a case, certain withheld information may have made a juror more sympathetic to the defendant's theory of the case. Yeah, but there's no way of knowing that. Additionally, in voir dire, the defense asked if anyone had, quote, experienced an abusive male, end quote. Based on juror 15's testimony at the hearing to interview jurors and Exhibit A in the defense notice of filing affidavit of Jack O'Keefe, juror 15 raised her paddle. This response clearly established that juror 15 had experienced domestic violence, contrary to her answer on the questionnaire. The defense chose not to conduct any follow-up questioning of juror 15. I don't know who Jack O'Keefe is, but maybe we'll find out more at the hearing. According to Exhibit A in the defense notice of filing affidavit of Jack O'Keefe, juror 35 also raised her paddle to the question, and she was seated on the jury. The defense did not exercise a peremptory strike against her. It's unrealistic to assume that the defense would have exercised a peremptory challenge on juror 15 for answering in the affirmative when it did not strike juror 35. Consequently, the issue is not material to the juror service and it does not warrant a new trial. As to number two, the son's alleged previous charge, The defense motion number 10 indicates that juror 15 responded untruthfully to the question, have you or a member of your immediate family been the victim of a crime? This question does not address anyone being charged with a crime. On the contrary, juror 15 checked yes to the question, have you or a family member been charged with a crime? The defense makes no representation that she inappropriately checked an answer that applies to her son being charged with a crime. Therefore, the defense has failed to establish that juror 15 withheld information. As to number 3, the defense alleges that juror 15 was untruthful by falsely representing that she had no involvement in child custody / domestic violence / abuse matters. As stated above, juror 15 raised her paddle when the defense asked if anyone had experienced an abusive male. The defense did not follow up with questions. Additionally, at the hearing to interview jurors, juror 15 said she did not recall if she raised her paddle in voir dire when the state asked if any member of the panel had ever had a contentious custody dispute. She explained that while her ex-husband filed 2 petitions for injunctions, they were both dismissed. She also testified that her ex-husband never filed any child custody motions, and she never went to court over such matters, so she did not feel the question applied to her situation. In voir dire, the state did not explain further what was meant by child custody dispute, and it was reasonable for juror 15 to assume the question did not apply to her situation. There was a contentious custody dispute, and in fact, her son, who was the subject of that dispute, in that marriage, the husband claimed that she was the abuser, and then many years later, the son also wound up being arrested for domestic violence against his pregnant girlfriend. So it's the cycle of abuse, and I feel like this stuff is pretty relevant. Notably, the defense did not follow up with any questions related to child custody during voir dire. Due diligence is lacking when at best an ambiguity may exist which is not explored. The defense failed to exercise due diligence when it did not explore the question further. Since the defense cannot meet the 3 prongs of the De La Rosa test, the defense motion for a new trial should be denied on these grounds. And then with respect to juror misconduct, alleged presence of cell phone in jury room. This was the stuff that came out where a person or a YouTube user by the name of That Hoodie Guy was in the law and crime chat talking about, my sister's on the jury. She says, here's what's going to happen. And then it kind of happened. Yeah, I know the Ashley hearing is not, yeah, we're going to the Ashley hearing. I don't know who put that in the chat. FYI, there's an Ashley hearing being streamed right now. That's what we're doing here. The judge is on the bench. There's nothing happening yet. You didn't miss a thing. We're looking at the papers first because that's important. But thanks for telling me how to run my channel. I love that. Juror misconduct, alleged presence of cell phone in jury room. All 6 jurors gave testimony at the hearing to interview jurors. All 6 jurors said they did not have a cell phone in deliberation. They did not see anyone else with a cell phone during deliberations. They did not see any other juror away from the group for an inordinate period of time. They did not hear any other jurors speaking on a phone. As such, there's no evidence of a cell phone in the deliberation room, no evidence of juror misconduct, and the motion for a new trial should be denied on this ground. Wherefore, the state of Florida says, please deny the motion. XOXO, Suzanne O'Donnell, your favorite evil stepsister. I do not have a copy of that affidavit, and I do not know if I can get it in time. Matt White with a Y. That's our judge in this case. I wonder if Ashley will be in court today. I mean, it's a day to get out of jail. We'll see. I know. Isn't this so funny? People thinking Melanie isn't a professional and knows what's going on. It's so earnest. Do you think? I don't know. Do you think they're earnest or do you think they're being snarky? Yeah, I know. The Ashley hearing, it's right here. It's right here. It didn't start yet. Hello? There's no sound up yet. Love of the traveling Mary. For the love of the traveling Mary. It's like, go try and survive in the long crime chat. Go on with your bad self. Thank you. Thank you, Nicole. So freaking rad. I'd rather go over this than sit and stare at the Florida State Seal for an hour. This is why I follow your channel. Thank you. Thank you. And look what we do. We pivot. We go from one thing to the next. Then we're going to go back to Sarah Boone. And if this runs late, then we're going to start Sarah Boone late from the beginning of the afternoon stream. So that's that. I wonder if he'll rule from the bench, though, Carol. I wonder if he's going to rule from the bench because he's already had time to digest this hearing. He's already had time to digest the papers. So it will be interesting if he rules from the bench, considering the sentencing is supposed to be tomorrow morning. Right? Of course, right. Thanks, Tracy. Thanks, who, if anyone. Thank you. I stick up for myself and I stick up for all of you guys in the chat too. And if someone's going to post a snarky, nasty, ridiculous comment, it's going to come up on the screen. Like once you put it out there, don't think I'm not going to call you out. I see Reddit threads about me that I can't believe she put my comment up on the screen and then made me feel bad. Okay. Well, don't put it up on the screen. I mean, don't leave a stupid, nasty comment then. Yeah, I use my lunch break to stream. Boss move. Thanks, Mike.
All right, can you bring out Ms. Benefield?
Here we go. She's here. But Ashley's here.
Okay.
It's easy,
Are you
coffee
ready to
nut,
move
right?
forward?
It's not that hard. Think before you type.
Waiver of presence. Okay.
We're waiving
All right,
her
good afternoon,
presence.
everybody. We're here in 2020 CF 3014, State of Florida versus Ashley Christina Benefield. Ms. Benefield is not present in court. Her presence has been waived by her attorneys, Mr. Taylor and Mr. Pinnell. Present for the state is Ms. O'Donnell and Ms. Friel. We're here today for the oral arguments, closing arguments related to the motion for new trial. When we were last here, Mr. Pinnell, you were not able to make it for some reason, so the request was made as opposed to written closings that we do them orally. And it was my understanding that you're going to be doing that, so that's why we continued it or left it on for today. Are you ready to go forward?
I am. I just want to confirm that you also received my written submission.
All right, so here's what I received recently. I have an email from you to my assistant. This is Sunday, October 20th. So yesterday at 3:35 p.m. It includes defendant's memorandum of law in support of motion for new trial based on juror misconduct, Exhibit A, Exhibit B, Exhibit C. I received an email yesterday, Sunday, October 20th at 3:38 p.m. from you. It says that attached is case law that was mistakenly omitted from the previous email. I received an email Saturday, October 19th at 1:13 p.m. from Miss Duckett to my assistant. Attached is a filed copy of the defense's motion for downward departure. And then another email Sunday, October 20th, so yesterday at 10:07 p.m., saying it was supplemental Exhibit 2 to the sentencing memo, and it was several letters. That's what I've received in the last couple of days. Did I get what I was supposed to get?
You got. I submitted the memo and the 4 cases. It sounds like you received both of those.
Yes, I did. State, did you submit anything that I was supposed to review?
I did, on Monday of last week.
Yeah, we just looked at it.
It's, let's see what date it is. Should be the 19th. State's response to defense motion for new trial based on juror misconduct. Poster interviews, did you receive that one?
I don't see it in any of
And the mic, Suzanne.
packets. It may be upstairs. If not, I'm sure Kelly is listening and she'll print out a copy for me.
Okay, thank you.
But I will say that I have not had a chance to review either your response, state, or the
No, Jules is at Sarah-Boone in a totally different county.
defendant's memorandum of law in support of motion. The three exhibits, although I think I've seen the three exhibits. Those look like transcripts that I already had. And the case law. None of it has been reviewed because obviously it just came in. All right, Mr. Pennell, when we were here last time, I said I would give each side 15 minutes. It's your burden. Do you want to reserve any for rebuttal?
Can we reserve 4 minutes? And
I'll
believe
allow it.
Mr. Taylor was going to do 4 minutes, and then I would do, let me do my math, 7. Which I think is 4 plus 7 plus 4, I think equals 15. So yes, we're going to split the first 11, and then I'd like to do a 4-minute rebuttal if that's okay.
No. One of you can, I don't mind if you split the first and the closing or the rebuttal, but one person needs to make the first argument, second person needs to make the second argument. So how do you want to split it up?
I was intending to take 4 minutes to present facts. Mr. Pennell will take the remainder to present law. Of the remaining time, he wanted to reserve 4 minutes to be able to respond to the state's position. I would assume the court, once the state concludes, is going to ask Mr. Pennell if he has any rebuttal. That was the reason why.
And so if you want to reserve 4 minutes for rebuttal, that's fine. But I mean, Mr. Taylor, you've been doing this a long time. So if one of you wants to make the first, I guess, 11 minutes of argument, that's fine. But we're not going to split up the first 11.
When we were here last, Your Honor, I inquired about that, and I represented to the court, as we did the last time, that I would do facts and Mr. Pennell would do law. The court indicated that was fine.
Sure, if you want to spend the first 11 minutes talking about facts and then the last 4 rebuttal.
Come on, Judge. It doesn't really matter.
I don't think I even need to express how unusual it would be to split up an initial between 2 different attorneys. So
He's
one
the
of you
law
can present
guy.
in the first
He's the
11
trial
minutes,
guy.
and then in the second, whatever you want to reserve for rebuttal, you certainly can reserve that.
She's in jail, KPT, until she gets sentenced, which is supposed to be tomorrow. Then she gets transferred to prison.
That's exactly how we proceeded with the court's blessing. I did facts.
I'm only human. I know. It's
Which one?
ridiculous.
Which hearing?
When we were here last before Your Honor, where Mr. Pennell was present.
It was on a motion to actually decide whether you're going to grant the interviews.
And it was,
For juror interviews, I did the initial factual representation. The court then allowed Mr. Pennell to deliver.
all right, listen, I'm not going to get, okay, fine.
He's
Whatever.
hangry. Judge White is hangry.
It's okay with Your Honor.
He should have had a Snickers.
All right, you're on the clock.
Thank you. 3 inquiries were made by the court with respect to the juror interviews, and I'm going to focus on juror number 15, Sarah Walcott. Of those 3 inquiries, the first was the form, which was signed under oath, and the question was,
Okay, I've been asked to whisper because the court feed is very low. He can't find the microphone. The judge has a microphone. We have closed captions on, so it can help you, but they're not always correct. So guide your actions accordingly.
have you ever been the victim of a crime, quote unquote. The second question that was asked by me during voir dire was, quote, have you ever been involved in domestic violence courts, unquote. And the third question that was asked by Assistant State Attorney Suzanne O'Donnell was, quote, have you ever had any dispute with a significant other about their child or the custody of their child, unquote. The answers that Ms. Walcott gave at the voir dire phrase of the trial to the first question was no. She had not been a victim of a crime.
It was me.
And she signed the form under oath. As to the second question, she did not respond. Have you ever been involved in domestic violence courts? And as to the third question, have you ever had any dispute with a significant other about their child or the custody of their child? She did not respond. At the juror,
I apologize to interrupt, but is someone on Zoom?
If they're coming in late, I'm not going to stop the proceedings.
Okay.
Go ahead, sir.
I'll take the 15 seconds, Your Honor.
Yes, sir.
Okay, so you know who's coming in on Zoom is Tommy Benefield and Eva Benefield. They were allowed to come in on Zoom, and that's the noise that you're hearing is them coming in. And she's saying, there's people coming in on Zoom, and the judge is like, I'm not stopping the proceedings because they're late. Okay, this was scheduled for 1:30. It's now 1:38. And this judge is on time.
Her explanation at the inquiry that was made by the court as to the first question, you ever been a victim of a crime, was she took the position it was dismissed, so she didn't think it was applicable and did not equate domestic violence with a crime, despite the fact that Mr. Ballinger was handcuffed and arrested right in front of her. Number two, my question, have you ever been involved in domestic violence courts? Ms. Walcott said that too was dismissed. She did not think it was applicable as a result, and she did not understand the word involved. As to question number three, have you ever had any dispute with a significant other about their child or the custody of their child? Ms. Walcott said that too was dismissed, so she didn't think it was applicable, but she did acknowledge and admit to knowledge of injunctions and her ex-husband's decision to seek custody of their minor child, as well as admitting that there had been disputes about the minor child's custody between them. Now, I'd like to direct this to Your Honor personally, if I may. Based upon our culture, our education, and our social status, which I would suggest is quite similar, if not identical, as a parent, when you ask your child, did you say this? Did you write this? Did you do this? Words have their ordinary and intended meaning. And that is a phrase we hear and see repeated in appellate decisions ad nauseum. There is an expectation, Your Honor, as a parent that the response will be direct and truthful. And the reason is because you will use that to evaluate the remedy that you believe to be appropriate as a result of the conduct. Now, I want to repeat the three questions that
I just want to point out that we have more people watching than watching Law and Crime. So hit that button, smash that like, do the things. Did I just throw us backwards? Yeah, I did.
despite the fact that Mr. Ballinger was handcuffed and arrested right in front of her. As a result, they're about their child or the custody of their child. Did you write this? Did you do this? Words have their ordinary and intended meaning. And that is a phrase we hear and see repeated in appellate decisions ad nauseum. There is an expectation, Your Honor, as a parent that the response will be direct and truthful. And the reason is because you will use that to evaluate the remedy that you believe to be appropriate as a result of the conduct. Now, I want to repeat the three questions that
Right,
were
that's,
asked.
that's the time. I'll give you the extra time for the interruption. Go ahead.
Three questions. You ever been a victim of a crime? You ever been involved in domestic violent courts? Have you ever had any dispute with a significant other about custody of your child? What is confusing about any of those questions? What is not clear about any of those questions? While at no moment for purposes of this hearing, Judge White, she lied when she came in here and gave those explanations, and everyone present in this courtroom knows she lied, whether they refute it, whether they object to it, or they choose to remain silent. But here's the thing. Here's the essence, the gravamen of this dilemma. It doesn't matter if she lied or not, because it's not about her. It's about us, the defense, Ms. Benefield, and what we knew as a result of her answers.
All
And
right,
given
thank you.
our remaining peremptory challenge, we would have excused her had the court not excused her for cause.
All right, sir, that's your 4 minutes.
It's Neil
Give you
Taylor.
additional time.
Neil
Last
Taylor.
sentence. May I?
Go ahead, Mr. Pennell.
Thank
You have 7 minutes. You're on the clock.
All right. Neil Taylor wasn't allowed to finish his last sentence. The judge is hangry.
Judge, it's our position that this is obviously an important decision of the court, but it's a straightforward analysis under the binding decisions of the Florida Supreme Court in De La Rosa and Roberts, and of the second DCA in the Fegan case that we provided to the court. It's now indisputable that Juror 15 gave dishonest answers and incomplete information to the court in response to the questionnaire and during voir dire. Based on that information, Ms. Benefield and her attorneys were not able to make an informed decision as to whether they would exercise a peremptory challenge to her serving on the jury. And the second DCA in the Fegan case says that a defendant has an inalienable right to make a peremptory challenge based on full knowledge and a complete disclosure by the juror. And Mr. Taylor's correct. Whether Juror 15 did it intentionally or not is irrelevant under the case law. It's the effect on the defendant and her ability to make an informed decision about a peremptory. It's our position that the most egregious of the omissions by Juror 15.
Okay, a lot of people are confused. A lot of people are confused. Neil Taylor has co-counsel that's helping him. The judge was originally not going to allow it, but he allowed it. He gets 7 minutes. Neil Taylor got however many minutes. The stepsisters will be up next. This is also a defense attorney. Okay? Okay. Got it? Cool.
To acknowledge that she had been involved in domestic violence court. At the subsequent hearing, she acknowledged she was the petitioner in a domestic violence petition, and the court has copies of that petition. At the top of the petition, it says petition for protection against domestic violence. So makes no logical sense. She wouldn't understand that. She was also, more importantly, the respondent in two domestic violence injunctions, also entitled on top, petition for protection against domestic violence. And in the second one, her husband, and they're both filed by her ex-husband. The first one was her ex-husband and her son, their son. And then the second was on behalf of the son. In the second one, the ex-husband specifically asked for custody and was awarded temporary custody of the minor child. So her answer is that she did not know that she was involved in domestic violence courts are disingenuous and misled the defense in its decision-making process. Most importantly, the omissions are material, and there's a three-part test under De La Rosa. One, One of the elements is, did the juror conceal information? I think that's undisputed at this point. 2 is the information relevant and material to jury service in this case. And what the Della Rosa case says is, if a potential juror is similarly situated to the opposing party, then it makes reasonable sense that the other party will want to exclude that person for cause or peremptory. Here, by being the respondent and allegedly committing acts of domestic violence in a family situation, accused of threats and misconduct, it is similar to the allegations that Ms. Benefield made against Douglas Benefield. So those particular, the fact that she was a respondent in those 2 cases makes her similarly situated to Douglas Benefield and makes it clear that had that information been properly disclosed, Mr. Taylor and Ms. Benefield would have been suspicious of her, believed she may have been biased, and would have exercised a cause or a peremptory challenge. The third factor was the failure to disclose the information attributable to the complaining party's lack of diligence. And those cases discuss the sufficiency of the questions asked by the lawyers. And as Mr. Taylor, I think, adequately indicated, the questions in this case could not be any more clear. Have you been a victim of a crime? Were you involved in domestic violence cases? And have you been involved in a dispute about child custody with a significant other? There's nothing about those questions that are unclear. And if you look at the Roberts case.
Like how they're coughing on purpose.
In that case, they just asked about litigation, and the lawyer, the potential juror, apparently the explanation was that they didn't specifically say domestic assault or injunction, but they just said litigation was enough. Here we were more specific. There was domestic violence, course, and custody. In the Taylor case, Taylor versus Magana.
Yes, sir.
Under head note 11 of the opinion, they found that the questions were satisfied the due diligence inquiry because they were specific, unambiguous, and not cluttered with sophisticated or confusing legalese. Again, the questions here could not be more clear. It's our position that we've established the 3-part test on the De La Rosa. That shifts the burden to the state to show that any error was harmless. Under the facts of this case, they cannot meet that burden. And it's our position that the court is required by De La Rosa, Roberts, and the Fegan case to grant the motion.
Thank you, sir.
Go watch the end of the Sarah Boone video I did this morning, Marissa, for my take on the Judge Bev thing. It's at the very end of the Sarah Boone morning stream.
You're on the clock.
I just want to respond briefly to what counsel said about the Roberts case. If Your Honor reads the Roberts case, they did ask initially in the questionnaire about litigation, but one thing that was very important to the court was that Roberts' attorney during voir dire clearly clarified
It's the judge, the
this
one who's
inquiry.
coughing.
And he said, has there been any kind of lawsuit, divorce, collection of a debt, breach of contract, assault and battery, auto accident, defective product, medical negligence, divorce, domestic assault? And that's pretty clear. So that's why the Roberts case said it was clear in the Roberts case. It wasn't because of the questionnaire that said, have you ever been involved in a lawsuit? And if Your Honor reads this case, I think you'll see that the court would have a very different opinion if it had just been the questionnaire itself. So I do agree with the De La Rosa 3 elements that the defense has to prove. I do not agree that they have met those burdens. These facts are not undisputed whatsoever. I think the only one that could be termed as undisputed is the first thing that the defense mentioned that was the questionnaire where juror 15 marked no when it said, have you ever been a victim of a crime? She testified that she answered no because she misunderstood. However, I do agree that that does not make a difference when you're looking at the case law. But nonetheless, she did raise her paddle, Judge, later on when the defense asked, has anyone experienced an abusive male? She raised her paddle. She testified that she raised her paddle, or it's in
She doesn't
her
remember.
letter that she gave to the court. Also, in Mr. O'Keefe's affidavit, Exhibit A, where it said,
Wait, did she testify under oath that she raised her paddle, or she wrote a letter to the court that wasn't sworn? That's important. That's an important distinction.
has ever experienced, excuse me, it says experience abusive male, and it has the number 15 written down. She raised her paddle. So even if she said on her questionnaire she was not a victim of a crime, she did raise her paddle when she said, I've experienced an abusive male. So I don't think that it's clear that this was not rectified and remedied with that question. But however, even if the court believes that it was not rectified, the defense never followed up with any of these questions when they asked, has anyone ever experienced an abusive male? The defense never asked juror 15 any questions about this abusive male, never exercised due diligence, which is the third prong of the De La Rosa test. And also, Judge, and maybe most importantly, is that this issue, being a victim of a crime, is not material or relevant to the jury service of juror 15. That even if she withheld this info, that she was the victim, that's all we're talking about here, the victim of domestic violence, wouldn't that make her more sympathetic to Ashley Benefield, who was claiming she was the victim of domestic violence?
We talked about this,
So
but no.
to insinuate the opposite, I think, would be disingenuous.
Would it? Talk to people in the chat. Talk to people in long crime chat. I was abused way worse than Ashley, and I never killed anyone. You're wrong.
It would align her more with the defendant than it would Doug Benefield. And perhaps most importantly is this issue could not have been that material because another juror, according to Mr. O'Keefe's affidavit, raised their paddle when they were asked, have you ever experienced an abusive male? Number 35 raised her paddle, and she was seated on the jury. She was never struck, and she was never asked any questions about the abusive male. So it's hard for the defense to try and say that this is material when they did not treat juror 35 any differently than they did juror 15. So the state's argument is that they have not met their burden, the De La Rosa factors on the first issue. The second issue is, have you ever been involved in domestic violence courts? First of all, Judge, the term domestic violence courts is very vague. I don't even know that I know what a domestic violence court is.
Really?
Is that criminal? Is that
Then you need to tighten up your game, prosecutor. Wow. You don't even know what a domestic violence court is? Okay, cool.
civil? Is this an injunction? Is this a divorce decree? What exactly is this? And I think
Domestic
it was
violence and
incumbent
divorce
upon
don't
the
necessarily
attorneys
go hand in hand.
to establish that and to flesh that out. And if you took the defense's transcript, or you were here, they did not delve into that domestic violence courts and did not expound any on what exactly is a domestic violence court. Just because there's an injunction doesn't mean that anyone ever went to court or that anyone ever argued it or that a decision was ever made. So as to whether the information was concealed, this information was never concealed because these items were the injunctions, which is what we're specifically talking about, were dismissed. They were not litigated. There was no follow-up questions by the defense, so there was no due diligence. And then I would argue again that they're not material or relevant to this juror's jury service, and it would be the same argument as the previous issue. As to the last issue, have you ever had a child custody dispute? That was something that I asked. Juror 15 testified that she does not recall whether she raised her paddle or not. So I don't know that we can say that she didn't raise her paddle, but she said she did not recall. She did say that she did not see these issues with injunction as child custody dispute. She said to Your Honor that nobody filed for any motion to amend child custody, or nobody went to court for a divorce court or family court to amend the custody agreement. And Judge, if you notice from the transcript, the state never defined what child custody dispute meant. I never went into
Do we
what
need a
exactly that
definition?
meant. I never asked them specifically. I just asked child custody. There is a real possibility that these allegations were not even termed as disputes. Just because someone makes an allegation doesn't mean that there's this contentious dispute. It's just someone's making a wild allegation. The wild allegation is dismissed. So she did not withhold the information because, technically speaking, there were no child custody disputes. There were no motions to amend child custody. And again, the defense did not follow up with the questions because the defense did do questions after the state's questions. They did not expound or clarify any of the issues related to child custody. So for these reasons, I would say that the defense has not met their burden under De La Rosa, and I would ask you to deny. Thank you.
All right, Beth, she lied to the court. Sit it. We don't know what child custody court is or domestic violence court. What? That woman was the prosecutor. She's against Ashley, Margaret.
Pinnell. I had to look at my phonetics. Apologize.
It should be.
You actually,
The way it says it's an E, so I no worries.
sir, you actually had a little bit of time left from before, so I'm going to add that in. So you got 4.5 minutes.
Appreciate it, Judge.
Yes, sir.
The state's focus is in our position is misplaced. They're focused overly on the abusive male question. Certainly, there's a difference between encountering an abusive male, and you could be abusive verbally, physically, doesn't necessarily make you a crime victim. But that's besides the point. When you read our memo, you'll see that we're relying primarily on the omissions in response to the question about domestic violence courts and child custody. And to suggest that an individual that filled out a petition, filed it in court, and the petition is entitled Petition for Protection Against Domestic Violence, doesn't know that they're involved in domestic violence courts, or that the question wasn't sufficient, just defies logic. No one can reach that conclusion. No reasonable person can reach that conclusion. The question's clearly sufficient. She filed it with the court. Then there was 2 petitions filed against her in court with the same title. And the idea that it's not a dispute, well, I don't know. The last time I checked, the court cases said, quote, ex-husband versus Juror 15. Seems like a dispute to me. He's asking for custody until she's mentally stable.
Mm-hmm.
The judge grants a temporary injunction, and that's Exhibit D to the memo, and the judge grants custody. If that's not a dispute about custody, I don't know what is. So the questions were clear on their face. The answers are obviously evasive, and there was an omission. And there's no evidence that any of these questions were vague or unclear. The other jurors raised their paddles. They didn't have any problems. It was only Juror 15. So it's our position, and again, by being a respondent who is alleged to have committed acts of domestic violence against her ex-husband, which also involved a child they had together, puts her in a similar situation as Douglas Benefield.
Mm-hmm.
And this isn't just me saying it. This is De La Rosa. This is the case from the Florida Supreme Court that both sides agree is the controlling decision. And it says, quote, a person involved in prior litigation may sympathize with similarly situated litigants. In these circumstances, counsel must be permitted to make an informed judgment as to the prospective juror's impartiality and suitability for jury service. That was not, Ms. Benefield did not have that option here. Ms. Benefield's lawyers did not have that option here. Because she did not raise her paddle to the involvement in domestic violence cases with full knowledge that she'd been involved in at least 3 domestic violence injunctions. So under De La Rosa, she's similarly situated to Douglas Benefield. And I think the case law requires the court to grant the motion. And I don't have any additional argument, but if the court has any questions, I'm happy to answer.
No.
If the court has questions,
I'll take your questions. Good.
any of these arguments, because to me, the law, again, the Florida Supreme Court, De La Rosa, Roberts, and the more recent case from the second DCA, all binding decisions simply require the court to grant the motion. No one likes to do a trial twice, but the defendant's entitled to a fair trial. That didn't happen here, so we'd ask that the court grant the motion.
All right, thank you both very much. Obviously, I received quite a bit of information. Even state, I haven't had a chance to review your response with the hurricane. Let me also say, I hope everybody's homes and families are okay from these 2 storms that came through.
Terrible.
I wanted to really wait until today to hear the arguments from both sides. Obviously, I kind of went into the weekend thinking that I wasn't going to have any memos or case law sent to me. It's all last minute. So I have not had a chance to review it. I think in all fairness, it's important that I review both sides, the response from the state, the memo from the defense, the case law. I think, as you mentioned the names, I believe that I already had all of those, but certainly go through all of that. So I really wanted to wait to see how much I had and whether I thought that I might be able to make a decision and get an order written today. And I leave this hearing firmly convinced I'm not going to get it done today. So we're not going to be able to do the sentencing hearing tomorrow.
Yes,
I don't know when
postponed.
it's going to be rescheduled. I'll have Kelly reach out to both sides to schedule it. What do we set for tomorrow? 3 hours?
I don't think, Your Honor, respectfully, we had a limitation on the time frame.
It was set for 2 hours, Judge, 8:30.
Yeah, I know I set limitations on scheduling. Whenever we set it up, I always say, how much time do you need for your portion of it?
I would like to hope we can get it done in 2 hours. It might be a little tight. To the extent the court could stand it, I'd ask that the court allot 3 with the understanding that we can wrap it up.
For both sides or just your side?
I think we're going to need probably 2 hours for our side because we're going to have some testimony.
All right. State? I think last time we talked, it was an hour and an hour, but now it's 2.
An hour.
All right. So 3 hours. I'll have Kelly reach out to both of you to find a day and time that works for everybody. And I will endeavor to get a written order out on this. What I'm saying is, I don't know how I'm going to rule on this. There's quite a bit of information to review. But I want to go ahead and set the sentencing hearing so we have a day and a time. And then depending on what my ruling is, obviously if I grant it, then there is no sentencing hearing. We pick another trial date. If I deny it, then at least we've got it on the record for a sentencing.
2 matters, if I may.
This is over. We're going back.
Advise the court I leave Wednesday for an out-of-town trial that's going to run approximately 2 weeks.
All right.
Number 2 is I would, based upon the court's decision to vacate the sentencing hearing for tomorrow, respectfully renew for Ms. Benefield our motion for bond to the trial court.
Yeah, it's been denied.
When the sentencing hearing now will be rescheduled. I think it's a reasonably fair bet that the court hasn't reached a decision on this issue. I think it's a troubling issue. And I think for those reasons, Your Honor should reconsider her bond status. And I would ask that the court admit her to bond pending sentencing. She's demonstrated for 3 years absolute compliance with every requirement imposed upon her. never been one issue related to Ms. Benefield's bond. And in fact, on multiple occasions, when she needed some relief, we petitioned the court. The court was always kind about it, and I think unanimously granted it each and every time. I don't even think the state opposed it. But the point being that she's never shown anything but respect for the opportunity to be out on bond, and any indication whatsoever that she wouldn't hear, and her family, as the court knows, is here as well.
All right, well, obviously that wasn't noticed today. The only way I can hear that is by consent of the parties, since it wasn't noticed.
Yeah, he's asking for her to be let out.
Well, we had filed the bond motion, Your Honor, or denied.
Yes, sir.
Denied.
But it wasn't noticed for
She's such a
today.
bitch.
And as you're well aware, I can't hear matters that aren't properly noticed except by consent of the parties. All right, thank you all very much.
Thank you, Judge.
Okay. Why is the sound so low? That's a court TV long crime issue, not mine. And they don't know how to use mics, but the judge has one. Okay, every time, everybody recalibrate your own sound so that I can go back to speaking at a normal volume. Recalibrate your sound so I don't blow out your ears, so we can talk about what just happened. The judge is cranky. He needs a Snickers. He's hangry. He also sounds sick. He's coughing into the mic. Both sides were able to argue their position on the juror issue, 15 minutes each. In the beginning, Neil Taylor said to the judge, my co-counsel we'd like to split this up. We know we get a rebuttal, but in the first part, I want to do 4 minutes of facts, and then he wants to do the law, and then we'll do the rebuttal. And the judge got really mad, and he's like, no, you're not allowed to do that. One attorney has to do the beginning argument, one does the rebuttal. And then he changed his mind, I guess. He was swayed. Because listen, being a trial lawyer is totally different than being an appellate lawyer. They're two very different skill sets. Arguing in an appellate court or arguing the law in front of just the judge is a very different skill set than being able to perform for a jury. And so I'm glad he finally changed his opinion on that. He was hoping to rule from the bench today about whether or not he was going to give Ashley a new trial based on the alleged lies made by juror number 15 in the juror questionnaire and during the juror hearing that was held that was not televised. That's why we didn't cover it. However, the judge was presented with some more papers from, I believe, both sides over the weekend. And now he says, I can't rule today because I have all these new papers. And he's a very thorough judge. So he's got to review all the papers. Did he say when he thinks that he's going to have his decision by? Because I was distracted by the chat. And check this out. The sentencing that was supposed to be tomorrow is now going to be adjourned without date. They're going to have to agree on a date because he says, depending on which way I rule on this, the sentencing may be, it may be moot. We may not have to do a sentencing if I decide to give her a new trial. They asked for bond again to let her out on bail. The judge said, because you didn't tell the other side you wanted to argue that today, I can't hear it. However, they recently just did. It won't be today. That's all we know. Yeah, it can't be today. He's got to digest all his papers, and then he has to draft his decision, even if he's already partially drafted it. Because the arguments today, let's face it, they really didn't change anything because everything they argued was already in the papers that we've looked at. So there was really no new argument today. They just provided the opportunity to orally argue. Many judges do not allow oral argument. They just decide motions on papers. So he allowed it. He has more papers. He wants to take time, review it. I didn't know they were going to even do a hearing on this because I thought we were just going to, oh, it looks like Sarah Boone didn't even start yet. So we didn't miss a thing. We didn't know that there was going to be a hearing on this. This was just noticed last week. So I just got notice of it. And now we're here. Sentencing for tomorrow is adjourned. We need to see where we go from here. Your anger is gone. Oh, best channel. Thank you, Sandra, for your super chat. And Husky Lover Mel, you got to get Ashley's attorneys to come on. It would be so good. I don't know if they're allowed to. Is there a gag order? I mean, Neil Taylor did say that he watches the show. Jules told us that, and that he was very thankful for all of your support for Ashley and for treating this case fairly, in his opinion. So that was good. Jules is not there today because she's at the Sarah Boone trial. Thank you, Mrs. Bucket, for your super sticker. I appreciate you. Yes, Salty Sea Glass, he did say the jurors would meet with him. Like I said, that was a hearing that was held that we were not privy to. It was not televised. It was done outside of the eyes and ears of the public for various, obvious reasons, because, we're trying to protect them as much as possible. Although Juror 15's name has been out there. Thank you, Nicole, for your cash app. That's very kind and generous of you. And to everyone who came over here. Hannah says, I'm upset to say I'm not moved by the defense's arguments. It's different than trial. There's no jury. This is just to convince the judge. This is a law argument, not a fact argument. So it's not always moving or interesting, but it is a question of law for the judge to decide. Sarah said, I agree. Why are they being forced to stick to a time limit? You want justice. This is at the high court. Well, everything is already in the papers, like I said. So I'm not that upset about it or hurt by it. And you know that if I was, I would certainly tell you. Okay. Hope they get her a new trial. Yep. Everyone's got all kinds of opinions on this. Very, very strong ones, right? Nita, wow. Wow. I'm not a friend of Judge White, but he's better than the judge in Carly. Yes. Oh, yes. Oh, yes. Oh, yes. All right. If she does get the new trial, she will be able to get bonded out, I believe. Yeah, she will be, because she was bonded out before the trial too. I think it will be the same judge for a retrial. And I think that part of his crankiness today may have been because he was presented with these papers and he really wanted to rule on this today. So in any event, the sentencing for tomorrow has been adjourned. Thank you, moderators, for keeping it classy. Please do all the YouTube things. We had at least almost 1,000 more people watching on this channel than we did on Law and Crime. And you know what that says, my friends? You know what that says? More people are realizing that when they come here, we have a little bit more respect for survivors and victims than so many of the other chats. And that's because of you. It's because of you. It's because of your stories. It's because of you are warriors. You are survivors, and you have a lot of stories to tell, and people are listening. So thank you. Please hit the like button on your way out, and then I'm going to teleport you. Yep. Teleporting you over to Sarah Boone. We haven't missed anything. They haven't started yet. Safe travels, my friends. Thanks to the mods. Thank you, everyone. Do all the YouTube-ish type things that YouTube likes. Then be cool, be kind, be classy. It is not hard. I swear it is really not hard. Peace. Safe travels. I'll see you there in 3, 2, 1, go.